Council that the meeting is being webcast live this morning and will be available in the Supreme Court's archives later today. We have some outgoing members and some new members. Our outgoing members are Allison Ho, who's a lawyer at Gibson Dunn, partner there, nationally renowned appellate lawyer, and we're very grateful for her service to the council. Scott Jenkins, as it was, he's retired, district judge here in Travis County. He's served the council since 2014. And Scott was a great hand, and he chaired the council security committee when we recommended the judge to Surrey courthouse security bill back several sessions ago. So we're grateful to Scott for his service. Gary Belair is presiding judge of the municipal court in Ransom Canyon, and he'd served on council since 2009 and was thoroughly engaged in our work, and we're grateful to Gary for that. And then Polly Spencer, who's a retired probate court judge in San Antonio, in Bexar County. She had served on the council an astonishing 16 years, along with Chief Justice Raddick.
16?
Time flies, doesn't it? Judge Spencer made tremendous contributions to changes in guardianship law that were picked up by the legislature and Senator Zaffarini, and have really made a big difference. So we're grateful to them for their service. And then we have a new member appointed by Governor Abbott, John Gimbel, who is the district clerk of McLennan County. He's serving his second term there. He's a graduate of Tarleton State University, and has been active in the District and County Clerks Association here in Texas. And if John were here, I'd embarrass him, but his grandfather was Johnny Gimbel, which you probably don't remember, but he was a country western fiddler, music star of some note, and John doesn't play a lick, so it's just and then I've made a couple of pre-appointments, 2 reappointments, Chief Justice Raddick and County Judge Bill Gravel. And Bill's been on the council since he was Justice of the Peace, and now he's responsible for Williamson County, and we're grateful to have his help. And we have new judges, Emily Miskell, who's a judge of the 470th District Court in Collin County. She was appointed to that court by Governor Abbott in 2015. She practiced law at Coombs, Fuller, in Plano, and at Thompson Knight in Dallas. Judge Miskell has a BS degree from Stanford in mechanical engineering, and she is a licensed mechanical engineer in the state of California. And she's also a Harvard Law grad, so that's an interesting combination. Then I've appointed Maggie Sawyer, who's Justice of the Peace in McCulloch County. Welcome. And everybody knows where McCulloch County is?
Yes, sir.
All right.
It's the heart of Texas.
I'd say Brady, but that might not tell you much more. It's about 2/3 of the way to San Angelo, up on the Hubbard Plateau.
And we don't have this kind of traffic.
Oh, yeah. Sorry. Before she was Justice of the Peace, she worked for CPS for 21 years, and is married to a trooper, the Department of Public Service trooper. We appreciate his service. And then Kathleen Person is the presiding judge of the municipal court in Temple, Bell County, and has been on that court since 2007. She was a law clerk for the Loco Court of Appeals back a long time ago. a graduate of St. Edward's University in philosophy and religious studies, and of the Baylor Law School. She's been very involved in judicial projects, including improving the NICS reporting project that OCA had been involved in. So I thought we'd, since we have several new people, we'd just go around the room and introduce ourselves rather than call the roll. So Senator Zaffarine, we'll start with you.
All right, I'm Judith Saffiedini from Laredo, State Senator representing District 21.
I'm Bill Boyce from Houston, attorney practicing with Alexander DuBose in Jefferson.
My name is Bill Grabau, and I serve as county judge in Williamson County, Texas.
Vivian Torres, I'm a retired senior judge.
Kathleen Person, presiding judge Temple.
Rachel Race from Houston, Texas. I'm the non-lawyer here. The only one you can trust.
Kevin Bryant from Dallas, and I'm the general counsel for Crow Holdings in Dallas.
Maggie Sawyer, the Justice of the Peace in Macomb County. Pleased to be here.
Ed Spillane, I'm the presiding judge of College Station Municipal Court.
I'm Kelly Moore. I'm a retired district judge, and I'm presiding judge of the 9th Administrative Judicial Region.
I'm Sherry Raddick, First Court of Appeals.
I'm Sharon Keller, presiding judge of the Texas Court of Criminal Appeals.
And on the phone, please introduce yourselves.
Hi, this is Judge Valencia Nash, Justice of the Peace, Dallas County, Precinct 1, Place 2.
Emily Miskell, Judge of the 470th District Court.
Evan Young, Kenneth, lawyer. Kenneth Sachs from San Antonio, attorney in San Antonio. Good morning.
Just not on the phone. Okay. So we have a quorum. There's a quorum. You've seen the minutes of the last meeting, June 28th. Any corrections, objections to the minutes? There are none, they'll stand approved. I recall that we have a Centers of Excellence program that we worked on for a long time to design. And Michael Smith is here, I think, from OCA to tell us about the program and our new Center of Excellence.
Good morning. Thank you, Chief Justice. This is my first time in front of DJC, so if I wrote something at me. So as a report for, this is our first full annual year with the Centers of Excellence program. 2019 was the year we really tried to make sure we put rubber road and got a Center of Excellence recognized. The first two came through this council earlier this year, and they were the 214th District Court and the 347th District Courts out of Nueces County. As we close out the year, today we have Judge Villarreal in County Court at Law number 2, and there are two more outstanding courts that were part of the initial process for Centers of Excellence. One is Judge Miskell's court, who we are engaging with right now and will be touching base with at the beginning of the year. And the other is Judge Laird's court, County Court at Law 2 in Montgomery County. They will be, Judge Laird is up for on-site assessment in December, and Judge Miskell has put in a significant amount of work, and we are re-engaging her in the process right now. As we close out the year, we're really taking the opportunity to pull everything we've learned from this year together, check our processes, get everything set and ready to go, because on October 24th, we launched a webinar and introduced the program statewide, and we have seen a significant uptick in interest. So we have about 15 or so courts that came out from the centers, from the webinar, that were hoping to become part of the Centers of Excellence program. We are also engaged with El Paso County to evaluate and assess all of their county and district courts. And then we have also had expressed interest from Nueces County courts, and possibly Judge Madera has possibly hinted that she may want us to come back out and help her Nueces County become recognized as Centers of Excellence. So we're taking the next 6 weeks to really tighten things up and pull things together and make sure we're ready to scale the process and the program next year, and everything is on on board and ready to go. Without further ado, I'm going to introduce.
Remind us, General Mack, of what the Center of Excellence entails.
So the Center of Excellence entails basically engaging with the court, the Office of Court Administration and the TJC around 4 performance areas and all of the all of the compliance areas as mandated by Texas law. Those 4 performance areas are governance, case flow management, oh goodness, I've lost my train of thought. Governance, case flow management, access and fairness, and court management, right? And so what we do is we evaluate on the very front end, we send what effectively is a benchmark. We send them a process, a review that highlights what the court is currently doing. We ask them for a fair assessment. Are you doing this? Do you have these policies in place? They send that back to us. We then produce what we call a court profile for them that lists out where they're strong, where they're weak, and we work with them to basically set up a plan of action of what areas are they trying to improve upon, where are they looking to spend their resources, and how are they going to tackle these issues. Once that's done, it's really left with the courts to determine how they want to put their resources and time. And then after about 2 to 3 months with regular check-in, we review documents and then set up an on-site assessment wherein we just double check what they've sent us and what they've told. We go in, we conduct assessments, we ask some questions, we meet with staff, we sit in on court sessions, and then we come up with whether or not on-site we are ready to push forward with a nomination report, or if we'd like to see a little bit more work come out, and then we write the nomination report and put forward to the TJC. That's typically the process we're in. That has come through a number of iterations. Judge Maderi and Judge Klein were instrumental in helping us sort of nail down what that process would look like from a court perspective and how we could help the court get through the process, because that was really a tough sticking point for us and for them. All right, any other questions? Okay, so without further ado, I'm going to put forward and introduce Judge Villarreal of County Court at Law 2 in Webb County, out of Laredo, Texas. There are a number of things I could use to describe Judge Villarreal and Judge Villarreal's court. Dedicated, smart, compassionate, but I really think the one that really stands forward is passion. Judge Villarreal is very passionate as a public servant, and that bleeds into and is infectious. Anytime you talk to him, he is incredibly excited to talk to you and incredibly excited to tell you about the work he's doing with this court, and it bleeds over into his staff, who are equally excited and enthusiastic about the work that they do, down to the finest detail. And when I say down to the finest detail, they coordinate colors. So I really don't have much else to say other than Judge Villarreal has shown over the months working with us that he is a dedicated public servant. He is committed to improving court administration, and I'm afraid that now that we've gotten him started on the process, that he pretty much started himself, he's kind of become addicted to it and always is calling me and asking me about new things that we can possibly help out do. So we are happy to have Judge Villarreal stand forth as a possible recognition for Center of Excellence.
Senator Zach Rainey is one of your constituents. We'll say a word on his behalf.
Thank you so much, Chief. Just a few words on his behalf, on behalf of County Court at Law Number 2. Basically, this is the court that many of you who have served on the Judicial Council for years have heard me talk about. Not this court, but the court that he inherited. And it was absolutely the worst court in the state by our standards, by the audit of OCA. This is a court that was 90% non-compliant with laws related to governance, to guardianship. And Judge Villarreal took this court that was in shambles. There were cases, including divorce cases, that were 10, 15, and 20 years old. And if you look at the report that's before us today, we have figures such as in governance, he started at 80%, case flow management 100%, court operations 60%, access and fairness 75%. by our assessment when this process started. That's not where he started. His figures were deplorable. And he, on his own initiative, got that court performing so well that he moved up to these figures when OCA came in for the initial assessment. And if you see the report that follows, he is now at 100% in every single area. And specifically regarding guardianship, he took this court from 90% non-compliance to being the only court with 100% compliance with guardianship laws. This work is truly amazing. He works Monday through Friday, and he works from very early hours to very late hours and on weekends. He and his staff, with support from the family. And today he has his family and his staff with him. I know that he'll introduce them, but truly, this is a court and this is a judge who should be role models for the state. Because he not only has embraced a standard of excellence, but he has shown that he can take something that is deplorable and move it to a standard of excellence. And that is quite unusual, quite impressive, and this court is truly worthy of this particular. Thank you, Judge Guerra.
Judge, you're a great credit to the Texas hard work that you've done in Laredo, and this is well-deserved honor. Introduce your guests, if you would, and say a few words.
Well, first of all, I would very much like to extend my gratitude on behalf of my family, but above all, the courtroom users. Thank you so much to the Texas Judicial Council, Chief Justice, for your role and being an example and access. I want to extend my gratitude to Senator Zaffarini for her leadership, trust, and confidence in the judiciary, and for educating, motivating students through our Access to Justice Class in the Courtroom project. Thank you so much.
Tell us about that. Tell us a word about that.
So we have welcomed over 5,000 students from 3rd grade to high school and university students, where they get to come into court, not as juvenile respondents, which is one of the dockets, the juvenile justice docket that I hear, one of the dockets that I hear, but they come in a very welcome, warm environment, having read the materials prepared by Senator Zaffarini beforehand so that they have an understanding of what they're about to experience, and they get to see a full mock trial from start to finish, and they get to appreciate that process, and they get to serve not only as members of the jury, but all courtroom occupations, from court administrator, clerk, court reporter, bailiff, deputy sergeant at arms. They get to see the full range of occupations available in a courtroom setting. So the idea is when they get old enough and they get summoned to jury, they're going to be enthusiastic about serving on a jury. We've asked some of these students, what is it that, what are you thinking about becoming? And we would think to hear lawyers and judges. Some of these students say, we want to be jurors. So,
what was the last trial you had?
The last trial we had was Lex Luthor versus Superman. Fortunately, Superman was found not guilty of impersonation, not guilty of public indecency, or flying over restricted airspace.
Public indecency because he wears his underwear on the outside.
But thank you so much for writing those scripts, for engaging our students. This is a wonderful project to involve students, to motivate them, and to educate them. They can't get that education but for coming and being welcomed into a courtroom. So we're happy to be involved. We're so grateful for your leadership and your help. I do want to recognize all of the people that joined me today. My family, my wife, Lorena Martinez, my children, Sofia and Andrea, my sister-in-law, my nephews, my mother-in-law. My mother is here, my aunt, my father-in-law, and our staff, save for one person. Victor Vasquez, the director of our DWI court. Rigoberto Hernandez, probate court investigator. Odilia Cuellar, juvenile docket coordinator. Cindy Flores, civil family coordinator. Ms. Rosie Rivera, criminal coordinator. Gigi Noriega, probate court coordinator. And Roxanne Sotoserna, our court reporter. All of these individuals, both staff and family, are what make County Court at Law 2 successful. I heard it from Mr. Smith, but it is absolutely true. The synergy in County Court at Law 2 is energetic, it's ecstatic, it's electric. We really, really enjoy, and that's our youngest. We really, really, really enjoy what we do. We enjoy providing this good service and welcome to the public, and it all begins at home. We're celebrating our 6-year wedding anniversary today, and so this is an extra special day.
Yeah.
But, and there's also one other entity that I must thank, and that's the Office of Court Administration. The Office of Court Administration has been so helpful, so instrumental in not only helping evaluate our staff, but providing resources, and above all, they are accessible and always available through the app leadership of David Slayton, Michael Smith, Jeffrey Sukunawa, and Jeffrey Renard. I really thank OCA for their help. And we're very excited to welcome their newest employees, the guardianship compliance specialists, so they can come and continue to audit so that we can provide them new ideas to other guardianship courts making these evaluations. We're happy and delighted to welcome your new employees for those continued evaluations.
Judge, thanks very much.
If I may, there's also one person who couldn't be here today, Cecia.
Yes.
Cecia is Judge Villarreal's court administrator, and she also plays double duty as his court interpreter, and is equally energetic, and is unfortunately, fortunately away on maternity leave right now. So.
She is the one that keeps us all together. She keeps everything on track, and she not only administrates the court, but she also provides court interpretation, and being a court on the border, that's 60 to 90% of our docket, depending on the docket. So she plays double and triple duty sometimes. Now she's playing family duty.
So is there a motion to present the Center of Excellence to Webb County Court at Law number 2 and Judge Victor?
I proudly move, Chief, that we recognize Webb County Court at Law number 2 under the administration of Judge Victor Villarreal as a court of excellence.
Any further discussion? All in favor?
Aye.
Opposed?
Aye.
This is a little cramped, so we're going to take pictures in the courtroom in a little while after we finish the meeting here. And they're going to do something more fun, which is take a tour. So we'll excuse your family. Any of you are welcome to stay.
Can you open it so we can see?
Yeah.
Oh.
Here's to the court, and there's for the judge.
Very nice.
Yep. Thank you.
Well, I dropped my kid off at school this morning, didn't have any
As they're walking out, I wish that we could concentrate on how we can motivate more judges to do this. Because we recognize 2 district courts now, we have court of law, but we really should have a lot more than we have. We need to focus on what we can do to motivate more judges. Just fix her up.
Yeah, so as Michael said in his report, one of the ways that we agree, we're trying to get more courts engaged on this, and we, as Michael pointed out, we had a webinar about the Centers of Excellence on October 25th. I don't remember how many people were on it, but there was a significant number of people who participated. And that was October 25th. And since then, we've had a tremendous number of courts reach out with a great deal of interest. I have court staff emailing saying, my judge wants to know how we can get involved. So I think we're starting to see that, and we need to continue that push. But, having judges like Judge Villarreal and Judge Maderi and Judge Klein, sort of leading the way and speaking, and soon we'll have, I think at our next meeting, we'll probably have at least one, maybe two other courts to sort of start talking about the value. But yeah, I agree, we're continuing to work on that, and we will continue to work on that.
I would suggest that we consider two avenues. And one is that we work with our regional presiding judges and try to get them enthusiastic to work with the judges who work with them in turn. And the other is that I know that there's some judges who would like to participate, but they're afraid of that initial assessment, especially if they've served there for a long time. They don't want those figures in public. So maybe we should develop a system where the initial assessment is confidential, and you give them time to move up, and then you do the official assessment after they've had time to improve. So they don't look as bad as they are.
Yeah, right. That's a good idea. Because in his case, he inherited.
Yes, but he moved it up to these figures.
Right. Yeah, that's a good
And
idea.
all of that is by invitation at this point. It's not something imposed upon any of the courts.
That's correct.
Volunteering.
But that'd be another route, but probably
Yes.
not the beginning route.
Is there any formal application, or is it just kind of people contacting you?
So once someone indicates they are interested in pursuing the Center of Excellence, there's basically an application process. We give them the materials. Anyone who wants to do it is welcome. And the only limitation in how many can be in the pipeline is our ability to do the assessments.
Right.
But as as Michael was saying, we've got probably 15 to 20 right now that are in the pipeline that are beginning that work. That initial assessment that Senator Zafferini was speaking about is primarily a self-assessment. And if you look back at Judge Maderi and Judge Klein's, their numbers were even actually, I think, worse at their original assessment, but they're basically looking at themselves and figuring out where they can make improvements, and then ultimately moving up in the system. But yeah, there's a process that anyone who's interested is available to participate.
This is Judge Mitchell on the phone. So I had started this process last year, and one of the things, there was some initial assessment form to fill out, and then the second thing they did was send me a list of, hey, by the way, here's all the statutes a judge is supposed to be complying with. Reply with which ones you're complying with. And then 5 months later, I was like, yep, look at that. I'm complying with all of them because there were some things in our county that needed to be updated. So I agree that, judges want to do things right and don't want to be on record that if there's gaps. And so I just wanted to share that about my experience going through the initial intake process.
Judge Gravel.
I think it would be helpful too, Chief, perhaps at our next meeting, if Senator Zafferini could bring the resources that she had previously shared with us, because we do have some new members.
Yeah.
And I think it is a wonderful educational piece.
Oh, for the mock trials?
For the mock trials
happy
that
to.
all courts in Texas.
You just want the candy.
That's true. I only have 9 or 11 judges, so if you'd bring me enough.
Oh, right. I'll bring you some kryptonite pops. I'll be happy to, Chief.
Good. Until you see it, you just can't imagine how clever it is and how it gets the kids involved in the give and take of the courtroom.
It's very educational and it's very entertaining. And the students have helped us do a better job. For example, during the Q&A after the jury stepped out, one of the students in the audience raised his hand and said, well, who are we? And Judge Villarreal said, what do you mean? And he said, well, they're the jurors, they're the deputy court officers, who are we? And the judge said, you're the public. And they all went, oh. So now we named them the Court of Public Opinion. And they each get a badge, just like the jurors do. They all get a badge that says court member, Court of Public Opinion. And they answer the same questions that the members of the jury do. And so they're engaged, and then they go into a Q&A. So even that time is used very productively. And then all the children get a certificate of achievement, a mock trial scholar achievement certificate. They get the pops that are used, they're sugar pops that are used as an example of bribery being against the law, when typically one of the villains in the mock trial will try to bribe the judge and the jury. It's something like kryptonite pops in the Superman trial, and then they get imprinted pencils, one from the judge, one from me, and one from a county commissioner, and the lanyards with the badges, so they go off with a little bag of goodies. And Sandy Sachs, who's supposed to be with us, she might be coming in late, related to Ken Sachs, sponsors bags for them, so they have canvas bags to take everything in. So they leave with goodies and they're happy. And the interesting thing is when they first started coming, the students were terrified. They'd walk into the courtroom and they were terrified. And they would ask questions such as, did we do something wrong? Are we going to jail? They didn't know why they were coming to the courtroom. And that's when we started preparing them for the mock trials. So they come knowing the purpose of the trip, and they know that it's going to be educational and entertaining. We actually prepare them, including with vocabulary that they study before coming to the mock trial. We give them teacher tips. So it's a whole program. But it's wonderful, and the difference is an enthusiastic judge, because Judge Villarreal is so enthusiastic. This was all modeled after the program developed by Judge Ed Prado, who was on the Fifth Circuit, I believe, and now he's the ambassador to Argentina. He tried Superman, who did not know, Kris Kringle for 25 years. And then he tried Goldilocks for something like 10 or 15. So we based this on his scripts, and the difference was he used scripts from the ABA. We write our own scripts. So we now have 15 original scripts that we make available through OCA.
They're on the website, available for all judges to use.
Great fun. Try them.
Well, the strength of the third branch is in the public confidence in the rule of law and the justice system. We're very worried that lack of civics education generally is undermines that. So whatever we can do to strengthen that really helps public confidence in the courts. So thank you for all you've done.
My pleasure.
Representative Annie Murs joined us, and I think Chairman Jeff Leach is on the phone. Oh, and
That's correct. I'm here. Good morning, everybody.
Morning. And the district clerk and son of the fiddler, grandson of the fiddler. Wonderful. Okay, much of the work of the council is done in committees. You can be on any committee you want to. Just tell David and he'll see that you get plugged in. And for the new members, the process is the committees consider various different ideas in the particular areas of that they are charged with, and then make recommendations to the council for ways of addressing them. Sometimes through legislation, sometimes through rulemaking by the council, and other ways. So we'll hear from several of the committee reports. As the meetings progress, we sort of are on a timetable to make sure that we have, that the council has thought about all the legislation it is interested in by next summer, so that we can begin to draft that legislation and get it in the hopper by the fall, toward the end of the fall, and then we'll be ready to go pre-introduce the bills that we're really keying on and be ready to go for the legislative session. So that's kind of our overarching timetable. But our first committee report this morning is on civil justice. So Chief Justice Raddick.
Good morning. We met last week. We're just getting started, just like all the committees are. We got an update on the civil justice trends from Angela Garcia from OCA, and we discussed those trends, and we also talked about Tony Favela, who has been very, very valuable in many things, especially the Indigent Defense Commission, gave us an update on the possibility on the oncoming trend of online dispute resolution, which was very interesting. We also looked at the business courts landscape and discussed the family justice initiatives. So we hope to bring you a good report, many good recommendations, maybe some that didn't pass last time, we might try again. So we will bring you a more full report next time.
Any questions, Chief Justice Red? Good. Well, those are all big areas that we need to look at. The next is a report from the Texas Indigent Defense Commission, presiding Judge Keller. Jeff? Jeff?
Hey, good morning. My name is Jeff Burkhardt. I'm the Executive Director of the Texas Indigent Defense Commission. For the new folks, what we do, when you hear the Miranda warnings on television, you have the right to remain silent, you have the right to an attorney, we're the right to an attorney part. So in Senator Zaffarini's example, we make sure that Superman has an attorney, that attorney is effective, so that's what we work on. We don't do direct representation, we do funding, oversight, and we work to improve indigent defense throughout the state. You all may remember that we received a 42% increase in funding this past legislative session, which was great news. We were very excited about that. The downside to that, just recently, the trend, we've exceeded $300 million in expenditures on indigent defense across the state in 1 year. So we are still a relatively small portion of the funding for indigent defense, somewhere around 15% of the overall spending on it. The good news is with the additional funds, our board, and actually we have five of our board members here, Chief Justice Radek, Presiding Judge Keller, Representative Murr, the Chief Justice, and Judge Torres. The board in the past couple of meetings has used those new funds and invested them very wisely. I'm excited to tell you about a few different projects we're working on. Some of those funds are going to develop the first Travis County Public Defender Office and to improve the managed assigned counsel system in Travis County. Some of those funds are going to develop the first Harris County managed assigned counsel system down in Houston. We are working on a 27-county pilot for Padilla, and that's thanks to Judge Stubblefield. So that's a pretty exciting project. If that goes well, we hope to look toward going statewide with a project like that. We're working on a randomized controlled trial to study the presence or absence of counsel at magistration. See, does it make a difference if you have an attorney at the first appearance in court? We've increased funding for rural regional public defenders. We've increased funding for the Regional Public Defender Office for capital cases, which does death penalty representation in now 185 counties. Is that right, Judge Moore? Yeah, 185. Yeah. And then finally, I'm excited to tell you about one last thing, that Burn JAG funding, which is the single largest source of federal funds that go to states for criminal justice. For the first time, some of that funding here in Texas is going to indigent defense. So we have a project that we're about to kick off. We just got funding from the governor's office to do some juvenile defense trainings. We're working with the Texas Criminal Defense Lawyers Association on that. So that's my update for the Texas Indigent Defense Commission. I'm happy to take any questions you might have.
Questions for Jeff?
Thank you.
Thank you, Jeff.
Hi, this is Judge Miskell by phone. I have something that might require a legislative solution that relates to indigent defense, so I just thought I'd bring it up.
Sure.
Which is the federal government has changed its rule, and for the first time, the state 4E agency, which I think would be our Department of Family and Protective Services, can seek federal reimbursement funds for appointed counsel for indigent parents and children in child welfare cases. But it has to be, as far as I understand, requested through the state agency, and I don't think we have anything set up to be able to implement that, and so that might be something we want to look into before the next session.
Thank you, Judge. Yeah, so the Texas Indigent Defense Commission, we actually right now don't deal with CPS cases. However, it's very closely related to what we do, and actually we've been speaking a lot with David Slayton. We're aware of that funding, and we're trying to figure out where to go with that. So David, I don't know if you have anything to add to that.
Yeah, Judge Miskell, I would add that there have been some conversations since that passed the federal level, just for everyone's benefit. It would end up being about a 15% reimbursement of the costs that counties right now are bearing with regard to representation of CPS cases.
So the percentage?
It would be 15% reimbursement. And for those of you, I'm looking at Judge Gravel, but others of you that are involved in the cost associated with representation of CPS cases, it is actually faster growing than criminal indigent defense. It's not as large in the numbers, but the rate of growth is pretty significant. And so we've been working with the Texas Supreme Court's Children's Commission, as well as with the Department of Family and Protective Services, about a process for getting that request for reimbursement, about who should request that reimbursement. It's a little challenging in Texas, of course, because it's county by county by county where they're spending that. There's actually no expenditure of any state funds for representation in CPS cases. So trying to figure out how to request that reimbursement is difficult. So Judge Miskell brings up a good point. We are looking at that. I'm not sure it actually requires legislation. There might be a way to deal with some of that, but it's an issue. There was a proposal, there's two things. One is there was a bill that was passed by Senator Colkhorst. I can't remember who the House sponsor was, but the bill requires counties to submit to OCA, Judicial Council rule, reports on the amount of expenditures in CPS representation cases, because right now the state has no actual idea of how much money is being spent. That, of course, would be the first step in being able to claim reimbursement, is actually know how much we're spending. And then the second bill, which did not pass, that Senator Colkhorst, I believe, is still interested in, and there may be some interim charge conversations around this, is in the state looking at providing some level of reimbursement directly in those costs. So there's a lot going on in this area. It's certainly something we should look at. The council will certainly be looking at this because the council is required to adopt rules on those reporting. So we'll be bringing that back to you for consideration in the future. That bill's got delayed implementation, so I believe the first reports are due next November. So we'll be talking to you about that probably at the next meeting.
I don't know the answer to this, but how is it decided whether the department will represent, will be in the case, or the county? So as far as the state's representation, that is really a county decision about whether or not they provide a prosecutor or an attorney for the state in those cases. In many of the counties, it's the county attorney's office or criminal district attorney, depending on what the situation is, who's providing that representation, but it is in some places where CPS directly provides that representation on behalf of the state. With regard to attorneys for the family members involved in that, that is 100% a county responsibility. Judges are required to make determination about who's qualified to be on that list. There's really no true state oversight of that process right now, and some of that discussion is, should there be some more state involvement? Should the state, for instance, pay for attorneys for the child? Because the child gets an attorney appointed, is required by law to get a child appointed attorney, as well as any the mother of the child and any presumptive father. So it may not just be even one individual father. It may be multiple fathers, because until the point where they determine who the father is, everyone's entitled to counsel, and that entitlement for counsel is immediately upon removal at the first hearing. So. It's a very expensive undertaking, and as you all that are involved in this area know, those cases generally have many court appearances, so the cost is pretty significant, and it is building as the CPS caseload grows across the state. So it's an area where I think there needs to be some continued focus.
Chief, I would add from a local level that every Monday I look through the bills that we pay as a county. It can be anywhere from $3 million to $6 million a week. The overwhelming big chunk that I review are attorneys that we reimburse, psychologists, counselors, therapists. But if you were to look just in our simple Excel spreadsheet, you would see that the majority of legal reimbursement are all CPS related cases. And in fact, I've been to a couple of our family courts, and there's not enough room in the well, so to speak, when you have an attorney up there for every child, and the mom and the dad. And it is the heaviest lifting, I think, that local government does. And so the thought of even just a 10% reimbursement from the federal government would be attractive probably to 254 counties in Texas.
Saw you park up over there.
15%, even better than 10%.
Do we know why CPS cases are increasing?
I don't think there's a perfect answer to this. I think if you listen to CPS, you will see that the areas where there's tremendous growth, a lot of that is related to drug involvement of parents, and so a lot of the removals are related to that. There are maybe other reasons, but that's, I think, part of the issue. It is many of the increases are regional. So if you look, for instance, out in the oil field areas where there's more of a boom, there's an increase in removals out there. Maybe that's just a population issue, but also maybe other issues related to that. So I don't know if there's a good answer, except for those are a few of the reasons why I'm inside of it.
I would add only that I think a lot of things that we've talked about, David and I, that many of the things that we do at TIDC in terms of funding and oversight, a lot of that could be, if Texas moved in that direction, applicable to CPS cases. The overall spending, Judge Rebell, so for indigent defense, I think collectively we're about $300 million. For CPS cases, we're somewhere in the ballpark. I think our best estimates are 50 to 60. But while indigent defense grows like this, CPS is growing like that. So I want to thank David for helping. You know, we've been talking through it a lot. I also want to thank him for inspiring my new haircut.
Appreciate that.
Well, thank you, Judge Miskell. That's a great point, and we'll continue to work on that. Then let's go to the Justice Court. The Judicial Council reporting requirements, rules, and amendments.
So for those of you that were around for the last meeting, you will know this, but for those of you that don't, I'll just reiterate what we did. The Judicial Council has rulemaking authority for a number of things, and one of the areas that's the longest standing set of rules that the council has is with regard to reporting. Since the council was formed in 1929, it has required the courts in the state to submit data to the state with regard to the work of the courts. And in the last legislative session, there were a couple of bills that made changes to the things that the council collects. Those were Senate Bill 42, which was Senator Zaffarini's bill on courthouse security. That was actually in the previous session. Senate Bill 291, House Bill 3994. Those are all from the 2017 session, as well as Senate Bill 891, Chairman Leach's bill, and House Bill 601, Representative Chair Price's bill on mental health from the last session. There were also some other miscellaneous orders from the Supreme Court that required our updating of our reporting requirements. So the council at the last meeting adopted amendments to the rules, which were provided to you in the materials we provided for you. Those amendments that were adopted for the council last time for publication in the Texas Register, and we published those on August 9th, and we received no comments from the public with regard to changes, and so they are now back ready for the council's consideration for final adoption, and then we will republish them in the Texas Register as final rules of the council. So I'm happy to answer any specific questions you might have. The changes in the reporting requirements are quite minor, but they're just sort of cleaning up pursuant to legislation and changes that have been made.
So the statutes creating the council authorize the council to make rules on various different subjects, and these changes were made partially in response to legislation, but the council approved them before. Now they've been published, no other comments, so we're ready for final adoption. Is there a second? Second. Any other discussion? All in favor? Aye. Opposed?
Aye.
Motion passes. Then also we have for consideration the repeal of the collection improvement program rules. So David, take us through that.
Similarly to the one that I just spoke to you about, the council many years ago was required to adopt a set of rules with regard to improving the collection of criminal court costs, and these were rules that imposed certain responsibilities upon counties and cities, and we have spent many years in the council talking about these rules. Senate Bill 891, Chairman Leach and Senator Huffman's bill repealed the requirement that the council have these rules and the requirement that counties and cities participate in the collection improvement program. And so at the last council meeting, the rule was adopted, the council adopted a repeal of those rules since the underlying statute is gone. Those were again published in the Texas Register on August 9th. We received no public comment about those, and so they are ready for your consideration with regard to final adoption of the repeal of those rules.
So I'll just say another word of history about that. After the Department of Justice's investigation into the shooting in Ferguson, Missouri, they found no wrongdoing on behalf of the officer, but it called attention to the way fines and fees are imposed in mostly no jail offenses. And there were a lot of, about half of the Ferguson report is dedicated to all those issues. That's not why the department went in there in the first place, but nevertheless, it called attention to pressure from local governments on judges to collect fines and fees, the use of jail to punish indigents who couldn't pay fines and fees. So the whole country began talking about these issues, and the Conference of Chief Justices had a task force that convened about 100 people to talk about them. And so we began looking at them here in Texas, and Judge Gravel was really a leader in that. And we had this program that the legislature had required us to have to put pressure, I think is a fair way to say it, to pressure judges to do what they could to collect these fines and fees. So really a tremendous group of judges. I think Ed Spillane was on it too, and Ed, Bill, and others, leaders in the justice courts and municipal courts, made a bunch of changes in those rules, which led to legislation in the 2017 session, and a lot of improvements in the way that we collect those. And we've been trying to keep track of how we're doing. What's the latest on that, Dave?
So for those of you that are newer to this issue, Chief gave a great background. Senator Zaffarini filed a bill in 2017 at the council's urging, Senate Bill 1913. It passed. Basically what it required was that taking some of the things that we had learned from our study of the collection improvement program rules and making them statewide. And the particular thing that it does, sort of the biggest thing it does is, one, it requires judges to take into account at the time of sentencing the defendant's ability to pay court costs and fines and fees, and to tailor a plan for recovery of any sort of penalties that the state has imposed that meet the needs of the defendant. So that might include straight up payment of those if the defendant has the ability to pay. It might include community service if they don't have the ability to pay, but they have the ability to do community service. Or in certain situations where the defendant might not have the means to pay nor the ability to do community service, it does authorize the judge to waive certain court costs and fines and fees. A lot of the reason why that was being done is because there was a tremendous number of individuals who were being jailed because they weren't able to pay, which is contrary to constitutional provisions. So the bill basically tried to address that, and many other things it did. We've been tracking, at the Chief's request, we've been tracking since the bill went into effect and for years prior, what was the impact on a number of different indicator measures. And basically, we probably should give a full update at the next council meeting about this so you can see it, but a couple of things I would point out. One is that the number of warrants being issued by our justice municipal courts is drastically lower. And one of the reasons why we think that's important is, one, less people getting arrested for not being able to pay their court costs and fines, but it allows law enforcement to focus on other areas that might be more important than arresting people who just didn't pay their court costs and fines. Another thing that we've seen is an increase in the number of people complying through community service. Judges ordering community service at a pretty significantly higher rate. Less people being laying out and satisfying their fines and fees and other court costs through jail credit. So as you can imagine, I always say that someone satisfying court costs through jail cost the citizens twice. They don't get paid, and the citizens also have to pay to jail them. Obviously, sometimes that is an appropriate remedy whenever someone just thumbs their nose, but that is drastically down. And the most interesting thing that I think shocked us was there was a great deal of concern that these remedies would result in a significantly lower amount of money collected in these cases. And Judge Gravel quickly told us that wasn't going to be the case. I'm not sure we all believed him because he was an early adopter when he was a JP and said he was seeing actually increased collections in these cases versus decreased collections, which is sort of doesn't really make sense intuitively unless you stop and think about it. If you tell someone they're going to pay $200 and they don't have the money to pay $200, they generally pay $0. Versus if you work with them and say, can you pay $100? And they say, yeah, I'll pay $100. And then you get $100 instead of someone $0 and someone in jail. What we've seen statewide is the first year of implementation, we actually saw an increase of about 6% in the amount of collections, and actual monetary collections, as well as all those other positive things I talked about. And then this year, it's pretty much just leveled off in the second year of implementation. So it's been, I think, a remarkable success. Other states are looking at us saying, wow, if this really works that well, maybe we should take a look at it too. So I think it's been a very positive outcome for what we did in that area.
Chief Hubbard?
Yes.
Payment plans were another option.
That's
I think
right.
that has been very effective to give the judges that option of creating payment plans. And what we found incredibly is that in many courts, persons who couldn't pay their fees were getting $50 credit a day for being jailed, but it cost $80 to keep that person in jail for a day. So it was costing us $80 a day to keep someone in jail for not paying $50 and giving them $50 credit for that day. Incredible.
Also, waivers are way up, too.
Yeah.
So the waivers
Yes.
I think appearances are up too. I think people are more willing to come in when they know that court has an option for them.
Yeah, one thing, just so you know, and all the judges who work in these courts can tell you plenty of stories about this. One of the things the law did not protect before was if someone had a warrant for their arrest for failure to pay or failure to appear, and they chose to go to court to try to remedy that, they were many times being arrested at the courthouse trying to remedy it. And the law basically says now if someone is making an actual effort to get back into compliance, they're not allowed to be arrested at that time. And I think I even saw just recently the Austin Municipal Court sort of advertising this, saying, hey, come back to court, try to work it out. We're not going to arrest you while you're here if you'll come and try to work this out. So I think we're seeing...
Safe harbor.
Right, it's a safe harbor.
Chief, I think this is a wonderful example of what good common sense rules can do that can affect Texas. I think not only was it the right thing to do for defendants, but I believe it reduced our jail population.
Yeah.
And I think that it's not only the right thing to do for Texas, but for counties, but it increased revenue where we didn't expect that. It's a wonderful example of what a few subtle rule changes can do. Now it's effective legislation. And I think it's going to be better for Texas going forward. With that being said, I do make a motion that we repeal the collection improvement program rules.
I'll second that.
Any further discussion?
I would like to commend Judge Gravel and David. Probably statistically speaking, you can see the statistic, the data for indigency hearings. And that is amazing, the feedback that I'm getting in the justice courts from defendants saying, wow, I didn't know this was my option, that, you know, my situation hasn't helped, but if you're willing to take $100 and indigency is a real thing, it's amazing, the feedback, common sense.
Good for taxpayers, it's good for the defendants, it's good for the system. It's good
It's
for everybody.
constitutional.
Yeah.
It's constitutional.
And besides that, it's constitutional. Any other discussion? All in favor of the motion?
Aye.
Any opposed?
Aye.
The motion carries. We'll turn to the Criminal Justice Committee. Judge.
Okay, thank you, Chief. The Criminal Justice Committee met this Tuesday, November 12th, with our initial meeting for this session. And our charges this year relate to continuing work with the pretrial bail system, which we've worked on for 2 previous sessions. And our second charge is involving best practices and necessary reforms for youth in Class C misdemeanor matters. And this was a charge that was, I think, inherited from the Juvenile Justice Committee that resulted in good, we think, legislation last session that didn't make it through. And so we'll be looking at trying to carry that forward most likely. Our third charge relates to evaluating current practices relating to juries and grand juries. And then we were added a mission of looking at admonishments in firearms cases. And so in our meeting, we received some information related to criminal justice trends. And I'm not going to go into a lot of details, but bottom line, felonies are up, misdemeanors are down, and those are the trends that are continuing. The felonies in our cases are made up, the largest portion of them, 33%, are drug offenses, and drug offenses are up 51% since 2012. Assault family violence is up 81% since 2014. New misdemeanors have been steadily going down, and new Class Cs involving juveniles have been steadily going down. We have some ideas about what those things might mandate, and some of them are going to play into other committees like the Strategic Vision Committee. I think a lot of these things are going to end up working together. We received an update on our bail issues, and the committee will be looking at things that counties are doing, where the lawsuits are around the state and how they're progressing, and concentrating on things that we could recommend to the council that OCA could do for these counties without the need for legislation, to providing resources to judges to make better bail decisions. And that's the same thing we've been trying to do for the last two sessions, but OCA is working on their praise text risk assessment, and there are some impediments to that we'll continue to work on. The main impediment is manpower to put in data in a lot of counties where the systems aren't integrated, and so someone has to be there to put the data in to get the risk assessment done, and it's really a problem in a lot of counties. But we're going to be looking at ways to make those things work better for the counties. And I know the judges are still crying out for it. I still get calls from judges all the time. What can we do? They want to make good bail decisions, but it's just very difficult under current circumstances to get the information they need. We received a presentation from Ryan Turner of the Municipal Courts Education Center about the process of trying to, in terminology we use, kind of like a very informal deferred adjudication in Class C misdemeanors for juveniles to avoid juveniles having this on their record, which really does impact them later on, even if it's a Class C. And this is the legislation that everybody thought was a good idea last session, but didn't make it through the legislature. So we'll be trying to carry that forward. And then I think it was David that pointed out that our jury and grand jury statutes are still presumptively drawn so that you use the old wheel to draw your juries. And there's a lot of updating that might need to be done to look at those. We'll be trying to get information to the council about current practices in juries and grand juries around the country to see if we can make improvements to our system, including things like, there are a lot of issues around about the right to counsel inside grand jury proceedings, records being made of grand jury proceedings, and just all sorts of issues. I don't think we have any particular thing to look at. We just want to look at what the trends are and see if we can make some improvements or recommend to the council to make some improvements. And basically that's it. We'll start getting deeper into these issues. The last item David's going to talk about, I hope, in relation to our new business. And we did pass a motion recommending some admonishments related to firearm that came out of the governor's initiatives recently. And David's going to talk about that. But that's where we are, Chief.
So on bail, Judge Keller and I pushed as hard as we can on the legislature, and Representative Burr was good enough to carry legislation for us. And now it's time for the council to see what we can do. And I think while we've been pursuing a strategy across the street, as Ted Moore says, a lot of judges are now saying, we want to do better, and how can we do it? We're also at a point where a lot of judges have adopted some very bright line rules that we'll see how they work or whether they work, and have, I think, made our pitch about risk assessment even stronger. We've had, as Judge Moore says, judges all over the state saying, how can we do this? So the time may be right to give them a kind of a nudge on this. And I'm so heartened by the fines and fee history, because we have 2,100 judges, JPs and municipal judges who handle those cases, and there was a good bit of resistance when we first said maybe we should change some of this. And with leadership like Ed and Bill and many others, and the very active participation of the municipal courts education group and the Justice and Constables Association, we really, I think, brought pretty much most of the judges, maybe all the judges on board. So it can be done. We're going to try a new approach, and it's in good hands.
Chief, what we found is that some of the judges were seeing this as a revenue stream.
Yeah.
That was why they opposed it. It's unconstitutional, but it was a revenue stream for them. They did not understand that was not the purpose. So they have to live by it now. I have a list of names if you want.
All right, thank you, Judge Moore. We're looking forward to that. The Strategic Vision Committee, Justice Boyce will hear from you.
Thank you, Chief. The newly created Strategic Vision Committee met for the first time. We met yesterday, Senator Zaffarini, Judge Person, Judge Moore, David, and myself. That's not the entire committee, but it was the initial meeting that we had. Strategic vision is a fairly broad category, and so we spent some significant time trying to focus that broad description and really centered around two areas. And I'll lay those out a little bit, and I may also invite David to elaborate as well. One of the areas involves whether we collectively as the Judicial Council want to pursue a strategic plan. We looked at examples, one in particular from Arizona, which is a 5-year plan that the Arizona court system sets out for itself. And it was particularly striking to me reviewing this plan that many of the things that are captured in the strategic plan in Arizona are things that the Texas judiciary and the Texas Judicial Council are doing already. There's initiatives around pretrial release standards, procedures, and bail standards, mental health initiatives, all of the initiatives that come up for discussion from time to time in this body. And so it leads to the thought that it really could be a very helpful exercise to capture what the state is doing already, what the council is doing already, what the various commissions are doing already, and put that in the form of a plan that identifies clearly all the moving parts and sets goals and a time frame towards their achievement. That's one aspect that we discussed yesterday. In addition to the larger aspect that is sort of the looking ahead, looking around corners aspect of this exercise, to think not just capture what is being done now, but what do we need to do, what does the court system need to do to meet the needs of the people who use the court system and all the constituencies of the court system, not, including but certainly not limited to the people who are using or are in the court system, the judges, the lawyers, all of the constituencies that are involved. So I think those are the two aspects that we talked about in terms of the strategic plan. A second aspect that we talked about in terms of the committee's activities would be to look at the budgeting process for the judiciary, and while continuing to make sure that all of the various judicial stakeholders and judicial system stakeholders have input in the budgeting process, to think about whether there are ways to channel that process and streamline it when it comes time to presentation of that process to the legislature, with the goal of making sure that the legislature receives the information that it needs to make its decisions, while also improving how that information is delivered and making it a procedure that works well for the judiciary and the legislature towards the goal of making sure that needs are identified, thoughtfully considered, numbers attached, and presentations made to achieve the funding that the court system needs to do the important work that it needs to do. So that, in summary, is the topic of our discussions yesterday.
Questions, comments, or Bill? Good. Well, we'll look forward to that report also. Do you have any other thoughts or suggestions for Bill? Be sure to pass them on. Those are our reports. Right, David? Is that it? So we'll go to new business, which is, as Judge Moore mentioned a minute ago, is consideration of adoption of judicial admonishment rule. David, you're going to present that.
Yes, sir. So just a little bit of background before I jump into the specifics of the proposed rule. So if you're listening to the news, you're probably hearing a lot about at the federal level, there's a discussion about, and the state level is discussion about firearms. And at the federal level, there are federal laws that went into effect in 1993 as part of the Brady Act, which prohibits certain persons from purchasing firearms when they have certain disqualifiers. And some of those disqualifiers include felony convictions, misdemeanor convictions, domestic violence, mental health, inpatient commitments. So when someone goes to a federal firearms licensed dealer and a court has provided information to the federal government, those individuals are prohibited from purchasing a firearm in those instances from those federal firearms licensed dealers. So that is, we are not talking about that today. I just wanted to make sure that when you hear about the purchasing piece, that is a federal law, and those federal laws are certainly in the news today. But there are a number of instances currently in state law in Texas where individuals who have certain adjudications occur in a court then become ineligible to possess a firearm, and in certain instances ineligible to possess a firearm and ammunition. I'll give you a couple of examples of those. In current Texas law, it is a convicted felon cannot possess a firearm for 5 years after release from confinement following conviction, or release from community supervision, parole, mandatory supervision. So basically there's a 5-year ban from possessing a firearm. If they are found having possessed a firearm during that period of time where they are prohibited, it is actually a third-degree felony under the Penal Code Section 4604. There are other instances where there is a prohibition for someone who is subject to a family violence protective order or a magistrate's order of protection. So this would be in domestic violence cases where they are prohibited from possessing that firearm once they receive notice of that order, unless that person who's subject to it is a active, sworn, full-time paid peace officer. So there are several, I could keep going, there are several instances where current state law that's been in effect for many years prohibits individuals from possessing that. I should point out that on the protective order, domestic violence, there are specific state laws that also add ammunition possession to the prohibited items in those instances. So it's not always firearms, sometimes it's ammunition, so you'll see some reference to that in the rules, so I just wanted to point that out. So all that's been in place for a long time. There are a few statutes which currently require judges to admonish defendants of their inability to possess the firearm, but they are not consistent in all instances where the person becomes ineligible to possess a firearm or ammunition. And so in his safety action plan issued in September after the shootings in El Paso and Midland, Odessa, Governor Abbott included as one of his recommendations that the legislature should require courts to admonish defendants when they become ineligible under state law to possess a firearm. I think if you read the background behind it, there's really two purposes to this. One is that right now it's possible that a defendant may not know, if they're not provided any notice, that they are ineligible to possess a firearm, so therefore they could be breaking the law and not be made aware of it by any sort of judicial admonishment. And second of all, of course, the thought that if we admonish people that they're no longer eligible to possess, perhaps individuals who by state law are ineligible would no longer possess the firearms and actually comply with the state law. So as we were looking at this, the chief asked us once the report came out to take a look at it and see if there's anything that the judiciary needed to play as far as a role in this. And this is one item that we believe that the Judicial Council has the authority to put into place now versus waiting until 2021 when the legislature meets. And second of all, if the judiciary can do it for itself, perhaps maybe that's better than the legislature even doing it. And so before you is a proposed rule. We took this to the Criminal Justice Committee on Tuesday, and they have approved it made a motion to approve it in consideration of the council. Basically what the rule would say is, of course, it defines what a firearm is pursuant to state law. And then it just says in Part B of the rule, and the materials you have, Part B is probably the key piece, which says when a person, by entry of an order or judgment, becomes by state law ineligible to possess a firearm or ammunition, the trial court must inform that person of the person's ineligibility to possess a firearm or ammunition. And then it goes on to say that if the person's actually there in person, appearing before the court when they become ineligible, the court must admonish the person orally in a manner they can understand that they're ineligible to possess the firearm or ammunition, and provide them with written admonishment informing of that. I should have pointed out Governor Abbott's recommendation was it both be in orally and in writing. So obviously when a person's there before the court, the admonishment would be orally and in writing. And the second thing, of course, which would be a rare circumstance, that if a person is not appearing before the court when they become ineligible and the court has entered an order, then it would be done in writing. This is unlikely to happen very often, but it could happen where a person is becoming subject to a protective order, family violence protective order, where they don't show up, and therefore the protective order is entered in default. And so the thought would be in those instances, since they have become ineligible, they would be provided the written admonishment, which I would point out is already the law, that the admonishment must be a part of the order, but this would make sure that's done. The rule goes on to say that the admonishment is to clearly inform the person that possession of a firearm or ammunition could lead to additional charges, and the rule would require the Office of Court Administration to publish on its website model admonishment language and a written model admonishment form that the council would approve, presumably its next meeting or a future meeting, that a court could use if they wanted to. It'd be a model. They wouldn't be required to use that language or that form, but it would be a model so that courts wouldn't have to reinvent the wheel if they chose not to. And then the last part of the rule would be that OCA would be required to coordinate with the Court of Criminal Appeals, who's in charge of judicial education for the judges, and the various judicial training entities to ensure the judges are provided adequate training regarding the admonishments required by the rule and by state law. So that's the rule. The process from here would be that if you were to approve this rule today, you would be approving it for publication in the Texas Register like we did with the earlier rules we talked about. It would be required to be under review by the public for at least 30 days. be more likely longer than that, since the council is not scheduled to meet within the next 30 days. We would take public comment in case there's any changes or any concerns that need to be considered, and the council at its next meeting would decide whether or not to fully adopt the rule as a final rule, and or make any changes that are subject to the public comments. And so those are that's the proposal before you today that's been approved unanimously by the Criminal Justice Committee for your consideration.
So Judge Moore, you move that we publish this rule in the Texas Register.
I do.
Since that's a committee motion, it doesn't require a second discussion. Yes, Andy.
I have an observation, and I would like to elicit, especially judges from the bench, your observation on it. So this rule requires both a belt and suspenders, so it's an oral admonishment and in writing. And so does it set up any scenarios in the future? And I'm just trying to play through that, where one of those admonishments didn't properly occur, and defendant later complains about it, I think unsuccessfully in every circumstance, but it certainly would be something that would be pointed back to as a reason why something later happened. And then how does it impact whenever a waiver of a lot of admonishments occur, such as during plea? I know courts individually handle those differently. I know my district court, even though we sign paperwork in the plea papers where we waive all that, he still goes through the process, but I know that some judges can choose not to. We're doing both belt and suspenders. Is there another consideration where it should be an and or, where it's one or the other, but then judicial education simply says, hey, best practice would be to do both? Are we then avoiding future circumstances where somebody comes back and says, you didn't do both, so something bad happened, and we want to hold somebody accountable?
It wasn't a knowing waiver, kind of like
Yeah.
the Padilla
Right.
thing that people.
So I guess I throw it out there for discussion because I don't know the answer to that. I don't know if it's a significant thing in any way.
I think it's significant because it could be grounds for a reversal of some sort. I always did both, in writing and verbal, but you're right, it's like overkill. And it does give you a possibility where you'll be challenged on appeal and overturn those convictions with a knowing waiver.
The only thing I would say, I'm not a lawyer, so I'm giving basically the non-lawyer perspective here, which would be, the rule would require a person to be admonished about existing state law. So it's not like you're creating any sort of new requirement that just by admonishing them. I don't know whether someone could raise that to maybe your specific issue. The reason why the proposed rule includes both orally and writing was that was the recommendation coming out of the governor's office. Now, if this council wanted to do something differently, of course, you certainly could, or even down the road in the future, you could choose to change it, before final publication. But that's the reason why it's both orally and in writing.
Maybe since it was the governor's recommendation, we should do it his way, and then look at it, monitor it, and decide if we should change it to and or.
I just look at it from the point of, let's advance it a few years, and then you go back to the courts that are handling these, and do they see that as, okay, if they're not dotting all their I's and crossing their T's, if both A and B weren't properly done, a scenario plays out at a future event, and then everybody wants to come point fingers. Whereas if it was a scenario where you had an A or a B, so the rule was either an oral or a written admonishment, but best practice through judicial education would be, we think you should do both. Then if one is missed, but the other one was done, there's less likely to point fingers in the future. That's really what I'm looking at it from a standpoint of the judiciary's viewpoint.
What I would say, Chief, is if the council approves the rule for publication today, as is or even with change, we'll get this briefed by some of our lawyers and bring back to the council at its next meeting, perhaps some legal research as to what the possibilities might be because of this. And I know there may be some people in this room who can't comment on what that might be because they may ultimately see a case before them. But, we can get our lawyers on our staff to prepare some briefs for the council as to what the implications might be of your actions.
And work with the governor's staff.
Right, exactly.
And Judge Moore, I marinated on this topic, so I didn't bring it up when we had our meeting on Tuesday, but I've thought about it for a couple of days now.
Yeah.
It's just something
Well,
I
I don't see, as a practical matter, it's mostly going to be done in writing, because the judges have so many things that the defendant needs to be admonished about, that we go to great lengths to put them in a written admonishment. And so that we don't have to go over each individual thing with them in court. And so, now they've heard to go ahead and put it out there and see what kind of comments we get. But one reason I was thinking this was okay, the main reason is that OCA is going to prepare the admonishment for the judges, and we're going to work through that. And so I've been thinking all along more to have orally.
Was the governor specific that he wanted it both orally
Yes.
and in writing?
It's orally and in writing in his recommendation.
Could I ask a question? Chief, is there any harm in us voting on it as is and affording David and his team and perhaps getting some legal advice and seeing what the public input is? And then when we do vote on the final adoption, if we choose to change the semantics here, it seems to me that we would be making it less restrictive instead of more restrictive, and we would not have to post it again.
Yeah, I don't see any problem with it, and I'm afraid that if we don't do it that way, the focus will be on why were we different from the governor's report instead of whether this is a good idea or not. And we need people to focus on the substance of what we're doing, and not just whether we're at odds with the governor, which we're certainly not trying to be. We just want to do the right thing.
Bottom line is at the end of the period of publication. So this is the proposed draft rule for public comment, is if you approve it today. And at the end of that period, you can change it and finally adopt it, and that's what becomes the rule. So next time you meet, that's really the important vote. That's what will be the rule. And so to the degree you want to strike, let's say you want to strike the oral admonishment altogether, that is something you will have the ability to do before the rule becomes effective. And we would not start educating or preparing. We'll probably prepare for you prior to the next meeting an oral and written admonishment, just so that it'll be ready for you. But you will have the option at the next meeting to decide which direction you want it to go.
I'd also like to know that clearly some lawyer in the governor's office felt like it was important enough that it include both admonishments, and I'd like to hear that view.
We can visit with them further.
I think that's a good idea, because it would be simpler if it was just in writing. It would be simpler for the judges if it just said in writing. And that's a good point. I'm kind of like you. I wouldn't presume what a higher court would do. I wouldn't think it would make a difference if someone was admonished in writing, that they weren't orally admonished, how it could be something that would rise to the level of error. But you never know.
As a defense attorney, I get to go explore that option.
There's already someone.
Andy sees business.
We'll commit to briefing and bringing that information back. And I told Judge Moore that yesterday or Tuesday when we met that it would be our intent to take it back to the Criminal Justice Committee before the next council meeting, so that they could consider any public comments that come out of this and any other issues. So we'll take those briefs back to there. I know you're a member of that committee, so you'll get to see that. And anybody else who's interested, we'll make sure that you have that information.
And the point of whether that language in the governor's proclamation was intentional, or whether somebody just threw in an and didn't mind if it was an or.
Happy to explore that.
Other discussion? Ready for the question? All in favor of the motion, say aye.
Aye.
Opposed?
Aye.
Then we'll publish it.
You never know if you've done
He's consistent.
That concludes the agenda. Is there anything else? We'll go to the order. Next meeting is in February, but we don't have a date yet. So we'll find a date and get it to you as quickly as we can. And if there's nothing else, entertain a motion to adjourn. All in favor? Return. Thanks for coming.